All right. Well, welcome everyone. Welcome to the Wisconsin Bankers 2022 July WBA Compliance Corner. It's a brand new resource that Scott and I are looking forward to creating a monthly opportunity for you guys to learn some compliance things. So we have put together a short little video here for you, and let's launch into it. So on the very next slide, you will see we have here for you a bunch of topics for today. We're going to take a look at the CFPB's advisory opinions. We'll also look at two different releases by FinCEN. One happens to be an updated advisory on elder financial exploitation, and the other being BSA due diligence and customer risk assessment information. We'll also then talk about an interagency statement on a very similar topic. We're going to touch base on the CRA proposal that Scott's diligently working on. We're also going to talk about two different pandemic-related items. And then our very favorite topic these days, Section 1071, as we all work to implement the rule that is going to be forthcoming. So with that, let's go ahead and jump into our very first topic, that being of the CFPB advisory opinions. And first of all, as we go through the video here, you'll see that Scott and I have put an asterisk by the various different topics that we'll be covering. And that asterisk means that there'll be a link available for each of these topics. You can grab the resources directly from the link as we go through these different topics. The link will be posted below the video. So let's go back on the Wayback Machine real quick. And we know that back in 2020, the CFPB issued a formal process for which they are going to be issuing advisory opinions. And since that time, you'll see here on the list that they have listed a number of different advisory opinions, starting way back in the latter part of 2020. And bringing it forward to current, we had one issued here this month in July, dealing with the Fair Credit Reporting Act and permissible purposes for furnishing credit reports to users of those credit reports. And it's that particular item that we want to touch base with here just briefly. So when you look at that particular opinion, you'll see that the CFPB is primarily talking to furnishers and wanting to make sure that the credit reporting agencies are furnishing reports to people who have a permissible purpose to have ordered the report or reviewed the report. And so they're focusing in on bad actors out there, unfortunately, who have misused or who the CFPB believes does not have the permissible purpose to have the credit report. And okay, that's good to know. And all of us here in the banking world would say that we do have a permissible purpose. But there's some language within that advisory opinion that gave Scott and myself and Rose Oswald-Poles as well some concerns as we try to do our day-to-day account underwriting and renewal for our loans in particular when we're talking about the Marital Property Act. So let's talk about just a couple different bits of language within the advisory opinion that gave us some pause, and how we believe that we still have a permissible purpose underneath the Marital Property Act. So on the next slide, what you'll find is we've pulled specific language right from the advisory opinion. And here it's from page 7. And while I won't read it to you, basically what it's talking about is in the Bureau's eyes, when they're citing language right from the Fair Credit Reporting Act statute itself, they're looking at there being a permissible purpose as it relates to the specific consumer involved in the credit transaction in particular. And so here on this slide, you'll see where we've put in some emphasis of the language that's giving us a little bit of concern when we're talking about it relating to a user's request. So hang on with that. We'll go to the next slide, and you'll see that this language carries on. I know it's a big paragraph and take time to read the opinion, but this is the particular paragraph in question or in concern. And it goes through, and the Bureau is saying that from their perspective, when you're looking at section 604, paragraph A, number 3 of the Fair Credit Reporting Act, they're really looking at the permissible purpose tying back into the actual consumer themselves and that consumer needing to be part of the transaction in order for us as a user to fit into 604 of the Fair Credit Reporting Act. Again, emphasis being added here on some key language that Scott and I wanted you to hone in on. So let's take the CFPB's perspective and now look at the Marital Property Act. And on the next slide, what you'll find is these are the two state statute sections that Scott and I and Rose have long relied upon as the reason why there is a permissible purpose for banks to pull a credit report when we have a married Wisconsin resident who is applying for credit themselves individually. And so here we have Chapter 766 as our Marital Property Act. And point 56, paragraph 1, talks about the credit and when you're obtaining an obligation in the interest of the marriage and of the family. And when that is occurring, we as a creditor need to look at all of the income, look at all of the debt of both the applicant, married Wisconsin resident who's applying, and the non-applicant spouse. We need to consider them a unit together. And the Credit Reporting Act says, okay, we need to fit that need into a permissible purpose, which here we have a statute that says that we do. Further, when you look at point 55 of that same statute section, you'll find that when a married person takes out obligations during marriage, it's assumed that that debt is a piece of a loan that's being taken out in connection with the marriage, and that the repayment of that is going to be made from all of the marital assets and all of the individual assets of that married applicant. And so based upon Chapter 766 and the requirements of the Marital Property Act, we now have a permissible purpose for pulling those credit reports on both the applicant spouse as well as on the non-applicant spouse so that we can meet our duty as we need to underneath the Marital Property Act, regardless of what the CFPB has said on their federal law analysis underneath their opinion. So we wanted to bring that forward to the group. We know that this is a frequently asked question through our call program. We have included this particular topic as an item within our July WBA Compliance Journal. So be sure to read there as well. And don't forget to click on the links below to pull up those different resources for you. So that's a very, very quick overview on this particular topic. But moving forward on our next topic, the FinCEN releases, as we had talked about. So we have two items here on our particular slide. One on the left-hand slide is the one I'm going to address here in just a moment. We have a new advisory by FinCEN regarding elder financial exploitation. We've got the citation there for you, and again, it's available in the link below. So what they've done is they've gone through and they have identified two different types of activity that they are finding are their mainstreams of this bad action with respect to elder financial exploitation. They're looking at schemes that are theft, where you have known people who are unfortunately stealing from our elder customers, or then you also have scams, where you have the bad actors who are scamming our elder customers from their money. So the advisory goes through and identifies some new red flags to watch for, some new scenarios that they've identified as being common trends, as well as a reminder of what to put in your SAR, so that if you are needing to file a SAR in this scenario, please don't forget you need to mark the box that talks about elder financial exploitation, and also put the code in. And the code is, as we have here in the materials, FIN-2022-A002. And that then will allow for the computer programs of FinCEN to alert the reviewers that we have an elder abuse situation with respect to a SAR filing. So with that, I'm going to turn it over to Scott, and we're going to carry on with our release here.
Great. Yeah. So the second statement, also on BSA due diligence, is related to independent ATM owners and operators. And this statement is specific to the customer due diligence rule and those requirements as they relate, again, specifically to those owners and operators of independent ATMs. So this is not a rule change. So it's nothing new within BSA. It's nothing new within the customer due diligence rule, but it's a statement and a bit of reminder that customer due diligence considerations are risk-based. So again, this is specific to those independent ATM operators who, of course, is going to be an individual or an entity that is in the business of controlling an ATM. And again, owner or operator. So the operator may or may not be an owner. It could be your bar customer who has ATMs on their premises, or other vendors or individuals or entities that are operating ATMs. They then come in to open up an account at an institution that is required for the cash flow or electronic settlement transactions that are coming through these ATMs. Those accounts then are, of course, subject to the customer due diligence rule, CDD being subject to legal entity customers, which could certainly include one of these owners or operators. Now, the statement in that context emphasizes that customer due diligence procedures require risk-based approach. And that's really the big takeaway from this statement, is keeping in mind that customer due diligence is risk-based. The level and type of customer due diligence that you're applying is always going to be appropriate to the risks that are presented by each customer. So that includes ATM owner or operator customers. So there's no specific risk that the rule lays out. The rule is not saying to avoid these types of accounts or perform some specific CDD for these accounts. Rather, it's risk-based, as it is with all customers. It is the same with ATM owner operators. So no specific requirements, no additional requirements. The statement does discuss more specific considerations that you might look at specific to these customers. But again, that's going to be tailored to your institution, the type of businesses that you see, the type of owner and operators that you see. So if you do have those types of customers, make sure to take a look at that statement link being below the video again. Now, similar along those lines, we also have a joint statement on risk-based approach to assessing customer due diligence. Now, this comes from the agencies. So FRB, FDIC, OCC, FinCEN, and NCUA have all joined in on this statement, which is similar along the lines. The big takeaway, the kind of super short summary of this statement is that customer due diligence is risk-based. All right. So the statement is emphasizing that there are no specific customer types and there are no uniform levels of risks or particular risk profiles when it comes to assessing customer due diligence. And we, of course, know that the rule doesn't lay any of that out. So we're just reemphasizing in short that it has always been a risk-based approach and it's always been specific to each customer relationship, meaning that each bank has to tailor your program and your procedures in accordance with the type of customers and the type of businesses that you engage in. The statement also provides that the agencies and the rule does not dictate who banking services should or should not be provided to. So again, similar to what the FinCEN statement regarding those ATM owners and operators is stating, this is just reemphasizing as a whole that the rule does not specify who banks are required or not required or should be looking out to do business with. Rather, banks should choose what business relationships that they want, and then customer due diligence should apply to all of those in accordance with appropriate risk-based procedures. So again, on both of these, nothing new, no new rules, but an important reminder that your customer due diligence programs should be risk-based and are not required to be tailored in a specific way or to any specific business types, but rather should be tailored in accordance with those risk-based principles based on the type of business relationships that bank is looking to enter into. Moving on, as Heather had mentioned, we're going to just quickly talk about CRA as well. So this has been a long journey, as many of you have been with us on. But on June 3rd of this year, the agencies did issue their proposal to amend their Community Reinvestment Act regulations. And while we've been talking about this for a while now, way back to when OCC and FDIC first published their rules, and FRB shortly followed with their own rules, we've been following this process very closely. We've been providing input and feedback to the agencies along the way through the comment process. And one of our main pushes has been that any CRA modernization should come as an interagency rule. The agencies should work together through the rulemaking process to issue it together. So now we have that proposal on an interagency basis, a nice almost 200-page read with comments due next Friday on August 5th. So we've, of course, worked through that. We've gotten feedback and input from many of you and are working to finalize our comments for filing next Friday. I don't want to get into too much detail in the interest of time on what our specific comments are, but they will reflect our appreciation for the undertaking on an interagency basis. It's no small task, and so we, of course, want to thank the agencies for listening to the industry feedback in that regard. Also that the industry continues to support CRA and CRA's overall objectives and modernization of that. But also we have, as in the past, we'll be commenting and pointing out that there are some areas of potential concern and burden. As with all of our letters, we'll publish it shortly after filing, so that will be available for you as well. Along with that, on that slide, Heather has some quick updates on some pandemic-related releases as well.
Super, thanks, Scott. So we wanted to make sure that the group was aware of two different items. The first one being a mortgagee letter that was issued here just recently through FHA. And when you look at that mortgagee letter, you'll find that they have tweaked the current calculation for the effective income for borrowers. So for those of you that are engaged in this area of lending, you know that effective income for borrowers is a defined term and a calculation that goes with that. And so now when you go through the mortgagee letter, you will find that there's an exception to that general process where they've added in some additional components for us as underwriters to take a look at and consider when you have a borrower who unfortunately has a gap or a lower amount of income based upon COVID-related economic events. And the COVID-19 related economic events, that's also outlined within the mortgagee letter that we have referenced here. So please do take a look at that. It will broaden the opportunity for those that were affected negatively to actually qualify for an FHA loan. So that's a good thing for our customers who, in fact, are looking for such a product. So take a look at that. Both the announcement and the mortgagee letter are also links here for you as part of this video. The other topic that we wanted all of you to be paying attention to is some NACHA operations that, as you recall, they had provided some relief to us during the pandemic. And there's a series here of bulleted items that are actually going to be relief that is going to sunset here in October of this year. So they're going to be putting back into place certain timelines that they had ceased during the pandemic and certain notifications. So while Scott and I were not the ACH experts, we did want to make sure that you were aware of this so that you can make sure that you keep your ears and eyes open for materials that will be coming through your ACH contacts and make sure that the folks that deal with ACH have those procedures put back in place as we get closer here till October. So I'm sure you'll be seeing more directly from your ACH providers, but certainly here we wanted to make sure that you were aware of this. And again, as I've said before, resources in the links with the video. So you've got that additional item as well. But without giving up our time, we wanted to talk about our favorite new topic. Scott?
Yes, of course. So another rule we've all been aware of and have all been following closely is CFPB's implementation of changes to 1071 regarding, of course, small business lending data collection. And really, we just wanted to mention for you here that we are now expecting a final rule by March of 2023. So yes, it is coming. That is when we are looking to expect to have that final rule in our hands. So make sure to plan accordingly. And don't forget to take advantage of the resources available on our website. And we have examples of those, links of those on our slide here, as well as links in the description below. We've created a toolkit which includes a summary, discussion, checklist for planning, list of individuals who need to be considered, template resolution, policy considerations, and more. So it's really designed to be a comprehensive look at the rule, help you to work through that and what is going to change regarding your operation. We also know that training will be a big component of this as well. So in addition to that toolkit, we have a PowerPoint that you can use for your own purposes. You can use it for training. You can tweak it, use it as, again, another resource, another tool to help prepare for this rule that, again, we are now expecting to be finalized by March of next year. So again, links on there, links in the description. And then to wrap it up, I'll turn it back over to Heather.
Well, thanks, Scott. So we wanted to make sure, as always, that you are aware of the different resources and ways of contacting us. You know, certainly those toolkits that Scott just mentioned are out there on the compliance part of the WBA website. Also, education training is out there on the education tab. So please become familiar with the Wisconsin Bankers Association website to have advantage of those different resources. And always give us a call. We're happy to help out. And we look forward to implementing the 1071 here as we get that final rule and work through that. So I hope you've enjoyed our first crack at a video, and we look forward to our next month video. All of our videos will be posted on the WBA Compliance website as well. So Scott and I, we look forward to seeing you next month. Take care.
Bye, everyone.